Good afternoon, everyone. Welcome to the Appellate Division First Department. According to the sheet, there are more than 6 hours of argument time requested, so we know that's not going to happen. So please just ask for the time that you actually need in order to get out the salient points of your argument. I can assure you we are fully familiar with your briefs. The red light is for you, not for us. Obviously, if we have additional questions, we will put them to you. People v. John Doe, AKA Renee Luna.
People, 5 minutes, Your Honor.
Yeah. 525. Tillman versus the State of New York.
Good afternoon. Appellate request 10 and 5, please. Respondent request 8.
6 and 2 and 6. Thamel P is submitted. DeSalva versus Tall GC.
Appellant request 5 and 2, please, Your Honor.
And respondent request 6, please.
525. Nasra versus Eldios is withdrawn. Perez versus Hadazi. Do we have a respondent? No. Did you wish to submit? Hello, you can stand up. It's okay.
Yes.
Submitted. Thank you. It wasn't a trick question. Seriously. I mean, you know, it's okay. Carpenter versus 210 West 35 LLC.
Appellate request 7 and 3, Your Honor. Respondent 4 minutes.
524. Goldberg Westburn versus Wurzburger.
Appellate 4 and 2, please. Respondent 5.
424. People v. Shari Morales. That matter is submitted. 128 Second Realty versus New York State Division of Housing. That matter is submitted. Boyazi versus Integrity Trade.com. Trade.com. Interesting. .com. You can have a .com on it as a title. That matter is submitted, thankfully. Burt's v. the City of New York.
Respondent city request 5. Respondent Clayson request 3 minutes, Your Honor.
525 and 3. That matter will be called second. Justice Gesmer is recused on that matter. Weiss v. Vesinospolsky. Okay, this is like, you know, let's give it the most difficult names possible and the .com. Who's on this case? How do you pronounce this? Yeah, okay. I'm sorry, how much did you want?
4 and 2.
Okay, I'm gonna call you Weiss V. And respondent?
Respondent Vishnopolsky requests 4, Your Honor.
4, 2, and 4. Memajah versus Brotherhood Synagogue. The attorney is running late on that one. Oh, you're here. Okay, excellent.
Respondent 3 minutes.
4, 1, and 3. Tyree versus Vitale. He's on. He should be on.
Good afternoon.
Oh,
Mr.
good
Domino.
afternoon. Appellant, how much time are you requesting?
About 20 minutes is possible.
No.
15.
No. Sorry. 5 and 2. How much time?
Respondent request 5 minutes.
525. Quinn versus Agra Surgical is submitted. First case for argument is Tyree versus Vitale. Yes, appellant, whenever you're ready.
I am Matteo Danino, Your Honor, and I'm the appellant in this case. Thank you for the opportunity to address this honorable court directly. I would like to clarify some multiple misinterpretation and misconceptions that has been associated with my name and the action in the matter involving Carl Tire. I apologize for my English, as I am an Italian citizen. And first and foremost, I wish to emphasize that this entire case has been built on a series of unfounded accusations and misleading assertions. Basically, I'd like to address the pivotal aspect of this case, which is that the allegations of fraudulent transactions between my companies and another company named Transdesign. Now, the respondent has painted a picture of a complex kickback scheme involving Alessandro Vitale, another defendant in the case, and myself. However, these transactions were legitimate business dealings, and is essential to understand that the role of Vitale at Kaltire was not as an autonomous decision maker, but merely as an introducer of my companies. Now, the allegations put forth by the respondent are riddled with factual inaccuracies and misinterpretations. They failed to provide clear and convincing evidence of any fraudulent activities or malicious intent from my part. And it's important to understand that these transactions were legitimate business dealings. I mean, with a normal supplier of one of my companies. All these transactions were fully performed, were duly invoiced, accounted for, documented, and paid. And once my companies had paid Transdesign, the connection between how Transdesign use its own money basically cannot, I mean, use the money, including paying Vitale, cannot be debited to me because me or any of my company never had anything to do with the Transdesign or its management. And also, the narrative of the respondent is flawed by the assumption that Vitale had a kind of a unilateral authority to make purchasing decisions for Kaltire, which is fair from the truth. And this is also very noticeable since the complaint, because the
Mr. Danino?
respondent. Yes.
If I may. So, Mr. Vitale admitted that Transdesign didn't provide any services to you. So there's a question as to what the payment was for. And here, the plaintiff says that the payments were a kickback for getting contracts for your companies. Can you respond to that, please?
Of course. First of all, Mr. Vitale was not an employee of Transdesign, nor an administrator, nor an owner. First, I mean, the services were provided, and also I addressed the respondent to the accountant of the company, which was also the custodian of records of the company. So invoices, documents, I recognized work products provided by Transdesign over the years that were collected during discovery and were presented to me during my depositions. And also here, the whole thing is built on this slightly misunderstanding that I did not know what the payment were for. The problem is that during my deposition, I was presented only with bank statement and total amounts of payments. And it's like asking someone to remember what he had for dinner 6 years before, just looking at the date and the total paid to the restaurant 6 years before. I addressed.
I'm sorry, go ahead, ask your question.
But the total amount of expenditures to Transdesign was over $600,000. I'm not sure that's like asking what you had for dinner.
No, basically,
It
I'm
seems to
sorry,
me
Your
that's a
Honor,
more
that-
significant, it seems to me that that's a significant enough amount that you might have had some memory of what it was for.
Yes, I said what the services in general were provided by Transdesign. That happened over 4 years. It's about 35 invoices. There's no connection between the amount that my companies received by Kaltire to the amount that my companies paid to Transdesign. So 600 might sound like a big amount of money, but is again in 4 years and for something like 35 different activities that spanned from market research to translations in multiple languages for a multitude of projects, big projects. And this is very important to understand.
You have
These
time on,
projects,
sir, you have time on rebuttal.
Thank you. May it please the court, Eric Goldberg from Littleton Park on behalf of the respondent, Cal Tire. Just to respond directly to some of the points Mr. Danino just
Yeah,
made.
especially the statement that he had nothing to do with any of the invoices or the transactions.
He said that he had nothing to do with.
He wasn't aware of the transactions that were presented to him, or he had no recollection.
Oh,
of those?
at deposition, this was a deposition noticed far in advance. We specifically asked in discovery for any documentation reflecting what the $600,000 paid by him to the shell company was for. He produced absolutely nothing in discovery. And I presented, there were 22 kickbacks. At deposition, I presented him with his own bank statements from JP Morgan, the bank statements from Bank of Montreal where the kickbacks went, and went through each and every one and asked him what were they for, and he could not identify anything in particular. And it strains credulity to think that there's this, the wife of an executive at my client is performing over $600,000 worth of services for him in translation or whatever work. There simply is no evidence in the record. And his reference to invoices, none of those invoices are in the record on summary judgment, nor are they before the court. He did not put them in the record, and I think there's a reason. There's been a problem in the prior litigation. There was a litigation that preceded this one in the Southern District of New York where Judge Forrest found that Mr. Danino had fabricated evidence in a case. So there's a history here of fabrication of documentation. But putting that aside, there are no invoices. There's absolutely zero evidence in the record suggesting there was any legitimate purpose for these payments.
Well, that was the next thing. He contends that there was nothing in the record to show that the payments sent through Danino entities were intended for an illegitimate purpose.
Okay, on that, Your Honor, this goes to the issue of whether Justice Boric applied the correct burden of proof.
Yes.
And in instances of fraud, particularly kickbacks, there's not going to be a handwritten note or an email saying, here's my kickback, go deposit it. The First Department has established, and we cited one of the First Department decisions, that circumstantial evidence is sufficient for a case of fraud.
It's a 1928 case, right?
You have a more recent one.
Oh, thank you.
Okay. 248 AD 2nd 168. That is KUOFENG Corp v. Ma. That's from 1998. There, the First Department found that circumstantial evidence was sufficient to support a claim of fraud. And Justice Boric went through that in great detail on the hearing, basically making the point I made, which is you're not going to have an admission of kickbacks in the record. But we had every single bank statement showing every kickback, and we had admissions from Mr. Vitale in a prior litigation where he said, I received the money from Danino that he sent to this company, Transdesign. It went into my pocket, yes. And he also testified that Danino did not receive any services from Transdesign. These were admissions he made in a prior litigation, and those, I would argue, that's direct evidence and beyond what we needed to prove a kickback scheme. And then just turning to the statute of limitations argument, that was something that Mr. Danino had raised in his papers. The applicable statute of limitations is 2 years under British Columbia law, and the statute starts to run when they're under the highest court of British Columbia held, it starts to run upon knowledge of the material facts of the fraud or of whatever the evidence, or whatever the issue, the claim is. The material facts here are the 22 kickbacks, or even one of the kickbacks. Cal Tire had absolutely no knowledge or reason to know of these kickbacks because Mr. Danino and his co-conspirator, Mr. Vitale, kept it hidden from my client. And therefore, and he points to some discovery in a prior litigation. None of that discovery indicated my client had any knowledge. My client, I represented them in that prior litigation. I asked them, please send me correspondence about dealings between Vitale and Danino, particularly because the prior litigation was a lawsuit by Mr. Danino against my client for breach of a contract. My client had never heard of the contract. Mr. Danino alleged in the complaint that Mr. Vitale had approved it. Given that my client had no knowledge of this contract, I directed them to look for communications between the two to understand what's going on here. Is there some sort of relationship between the two? And we asked in discovery, is there any sort of consideration going back and forth between the two, even exchanges did Danino provide clothing or hotel accommodations to Vitale or any of his friends? We had no knowledge of any kickback scheme. We only first had an inkling when I deposed Mr. Vitale in 2018, at which time he admitted, yes, Mr. Danino sent payments through this company, but they were all legitimate. He owed me money from some transaction years ago. We then obtained bank records in 2019, and that's when the first time my clients had a knowledge of the material facts of the fraudulent kickback scheme. Those bank records, thank you.
Yes, sir, you have 2 minutes on rebuttal.
Yeah, thank you. First of all, I want to say that Mr. Vitale had no power to involve Cal Tire into the contracts. His purchasing power was $50,000. All the contracts my companies provided were worth anything between 5 times that amount to 15 times that amount, meaning that Vitale was not the purchaser. The services were provided to the whole company. Second, the statute of limitation starts running when there's a reasonable suspect. And in my opinion, humble opinion, I think that asking a company for consideration and saying what's going on here, there's anything between these two parties is more than suspect, because Cal Tire had a lawyer investigating in this, and they threw allegations of fraud and unclean hands in writing more than 2 years from the beginning of this action. That is, Your Honor.
Any questions? Thank you. Thank you both. As I stated, we're calling out of turn Burt's versus the City of New York. Justice Gesmer is recused on that matter as per the rules of the Appellate Division. If there is a tie, a judge will be vouched in. You may proceed.
Good morning, good afternoon, Your Honors. John Weber, Appellate Counsel for the Law Offices of Nicholas Rosa.
No relation.
No relation.
No relation. So
Different
record's
spelling.
clear. Okay.
So, Your Honors, the first thing I just want to point out, this fundamentally unfair decision to dismiss the case against the city when the...
So we have inconsistent testimony. The 50H, your client testified to one thing. The deposition, he testified to something else, right?
Yes, Your Honor. So the notice of claim and the summons and complaint matched the 50H testimony. 5 years after the accident for this visually impaired plaintiff, he made a misstatement of direction.
Well, I mean, it's more than a misstatement because it goes to the location and to which crosswalk it is, whether it's crosswalk 1 or it's crosswalk 2. And then the other thing I did not understand is why did you not simply amend afterwards when you saw that there was an error, or at least correct the errata sheet on the 50H in the deposition?
So 2 things, Your Honor. Let me address the first part of what you just said. We stand up here so many times in here that a picture's worth 1,000 words and all this stuff. With the notice of claim and the summons and complaint, 7 photographs were submitted, particularly in the record pages 55, 59, and 60.
Yeah, I have the picture.
Are taken from angles where you could actually see the surroundings. That they can only have been standing in one of the crosswalks. Both crosswalks would not give you the vantage point that's presented in these
how is
photographs.
Pictures, however, didn't have street signs on them, so you couldn't directly say it was on this particular corner, on this particular corner. So you're saying that there was enough in those pictures to identify them and clear up any discrepancy?
Yes, Your Honor, because you could see storefronts. So if you're standing at the angle that is taken in these photographs, and you put yourself in that position and look, you can see the storefronts that are there in those photographs. That cannot happen from both crosswalks. The other thing that Your
Is
Honor
that what is
addressed-
required in a notice of claim and/or a 50H, is that all you supply are storefronts? And is that enough? Is that particularized enough to give notice as to exactly where the accident is alleged to have occurred?
Well, it's also in combination with the verified notice of claim and complaint, because the statements in those documents are sufficient to describe the scene combined with the photographs. Additionally,
So
there's only...
I did my own map. I made 2 separate little maps, and even having done that, comparing that with the testimony, the conflicting testimony, it is extremely difficult to figure out where the accident took place. Now, we know that prejudice can occur when the opposing party invests time in discovery to its detriment, because there was, for example, you're calling it a mistake. How does this not prejudice your adversaries here? There was, I believe, 7 years. There have been 7 years of discovery and in total 9 years of litigation.
They wasted 5 years from the point of the notice of claim to the deposition, the accident date and notice of claim to the deposition date to not investigate. So the Williams case that was cited, they have to give a modicum of effort. So if no investigation took place from the time the claim was filed,
Well,
there's no effort to adjust.
The city states that it directed DOT to conduct a 2-year sidewalk search for the intersection of East 59th and Lexington between the northwest and southwest corners, which they characterize, or which is characterized as crosswalk 1.
Crosswalk 1 is the location that was consistent. So the only inconsistency here was in the deposition, which is 5 years after the accident.
No, I thought crosswalk, see, that's the problem. I thought now that it's crosswalk 2 that we're talking about.
So the discovery issue with Con Edison is the issue with crosswalk 2 that we were talking about. So here, the thing with Mr. Burtz's consistency, there's no reason to have to correct we're talking about an issue of credibility. Had the city gone to the intersection and said, we can't decipher based on this, and had a discussion, these photographs point to a specific corner, one of the
Counsel,
crosswalks.
I mean, I understand, and I can appreciate your argument, but is that really what's required, right? I mean, the city has their own interests that they're protecting, and that would seem to be going above and beyond what they're required to do by the law.
The city has an obligation to get out and investigate in a timely manner. I don't think it's reasonable to say that 5 years after an accident is a timely manner to talk about an investigation when the photographs and the testimony and the pleadings point to one specific point in that intersection. You can't look at these photographs and look at the pleadings and then go to that intersection if you're an investigator and confuse where you're standing. There's a great manhole.
Do you, as plaintiff's attorney, have the same obligation to make sure that we're talking about the right location, the correct
This
location?
was verified by the plaintiff, pictures provided, and the obligation here is to describe the location with sufficient detail for the city to be able to investigate.
So here's
These are
Why
very
not move to
particular.
amend?
I'm sorry, Your Honor?
Why didn't not move to amend?
There was a mistake in not amending, but the amendment to the errata sheet would have only, the fact that that testimony is inconsistent is an issue of credibility, not an issue of whether or not the location is not
Why would
decipherable.
it not be more than an issue of credibility if it doesn't give notice to the city and Con Ed as to exactly the location that we're talking about?
Because when in the testimony, the same testimony, you're talking about the location he came from to the location he was going to. We could have a map here
He
and
says he walked straight east on 59th Street, but somehow we end up, as opposed to being on the southwest to southeast, yeah, we're on the north side. I think that's the issue.
Your Honor, the testimony, it's plaintiff's or appellant's position that the testimony and the pleadings that match the photographs are sufficient to be able, again, this is a dispositive motion where our client is defending a motion, and the fact that all of his testimony and pleadings and the photographs and evidence that were presented were all consistent until the deposition date should have been enough to survive this
Okay,
dispositive
you have time
motion.
on rebuttal.
May it please the court, Jeff Kerfman on behalf of the City of New York. Supreme Court correctly granted the city's cross motion to dismiss because the plaintiff's testimony contradicted the accident location identified in his notice of claim.
Well, what about this issue of the photographs having shown the storefront? So it's really kind of hard to miss where the accident happened.
But Your Honor, I would make a couple points. The first is that regardless of what the photographs showed, the plaintiff subsequently contradicted the accident location identified in his notice of claim, thereby in the record creating the possibility that the accident occurred in two different crosswalks. And in doing so, he prevented the city from determining whether it had any role in creating the defect, assessing whether it had any defenses to that claim, and deciding whether to settle or litigate this case, which the Court of Appeals has made clear is the plain purpose underlying the notice of claim statute.
So conceivably, we have 4 crosswalks, right? Lexington Avenue, 59th Street, there's gonna be 4 crosswalks. Could the city not do a search as to any notice of any defects or whatever in those 4 crosswalks?
Well, Your Honor, even assuming the city's record search covered the two crosswalks that he has potentially identified as the site of his accident, it still doesn't know which crosswalk was the actual site. And in order to evaluate whether the plaintiff
But again, if you look at the photographs, and I guess this is the one on 360 page, record page 364, it seems to show, I guess that's Bloomingdale's or whatever across the street. So it seems to show exactly where the incident occurred. Would that not give you enough notice?
A couple of points, Your Honor. First, with respect to the photo itself, there are 7 photos, and these photographs, they circle all manner of roadway feature in this crosswalk. I mean, they effectively circle the entire crosswalk.
Yeah, I don't even really see a crosswalk. It seems to be a manhole cover or something.
That's right, Your Honor. But beyond the photos themselves, the plaintiff went on to, even if those photos do depict the first crosswalk, the plaintiff went on in multiple rounds of testimony to identify a different crosswalk as the site of his accident. And in doing so, he deprived the city of an opportunity to understand exactly where his accident occurred and evaluate his claim accordingly. I'd just make one other point, Your Honor. With respect to the plaintiff's visual impairment, we are, of course, sympathetic to his circumstances, but the plaintiff has not put forward any authority holding that a visual impairment of this nature excuses his obligation to identify even the crosswalk where he fell. And moreover, we'd emphasize that he has not submitted any evidence demonstrating that his visual impairment in fact prevented him from identifying the correct.
Counsel, what's your response to your adversary's argument that this is an issue about credibility?
Your Honor, respectfully, the case law is quite clear that in order to provide adequate notice under Section 50E, the plaintiff has to provide the correct accident location to the city, so the city has an opportunity to know whether it had a role in creating this defect and evaluate its options as to whether to litigate or settle before the litigation unfolds over a period of now 10 years as we have here.
Thank you.
May it please the court, my name is Dan Ratner. I represent Con Edison on this appeal. our record search showed that any work that was performed in the location was on, I did a map too, the southeast corner of Lexington and 59th Street, which is near crosswalk 1 or 2.
That was in 2011?
We went back we went back 2 years.
A year and 5 months before?
Right, and that was a different corner. So it was a different corner. It wasn't near either of the two locations that the plaintiff described. Now, our search started out, of course, was in relation to crosswalk 1, right? Because that was in the complaint. So then, in opposition to our motion, there was the claim, well, it might be crosswalk 2. So then what we did was got another affidavit that said, well, the search encompassed both. It was the radius was big enough to encompass both locations. Now I just wanted to just point out that on appeal, in plaintiff's brief, they're saying that we never suggested it was crosswalk 2. It was always crosswalk 1. We just made a mistake in the deposition. Well, that's even better for Con Edison because our original search was, of course, looking at, specifically at crosswalk 1. So no matter how you slice it, Con Edison's, the order granting summary judgment on behalf of Con Edison, based on our showing that we did not cause or create a dangerous condition in either of the two locations that have been proffered here, that entitles us to summary judgment, and it wasn't rebutted.
Thank you.
Thank you.
Thank you, Your Honors. With reference to the city's argument, the cases that are cited are all completely different, and they're much more prejudicial to the city than what we're talking about as a possible mistake in this single intersection. You have a case, Caselli, that there's no photographs and it's vague. You have other cases where it's actually at a different intersection altogether with different streets. It's not the same thing as providing pictures with a vantage point where you can clearly see unique features in the roadway that can only possibly be at one of these corners. You have a very distinct manhole cover with encircled in a different colored concrete. You have a grate with several pictures showing the chips in the concrete and the grooves that cause the accident. And plus, these are circled.
I'm sorry.
These are
your position that manhole cover correlates to the work that was done in the southwest quadrant?
It is in the...
Or is it something different?
This is in the intersection that was pled in the notice of claim, and it's it is the southwest corner of East 59th Street in Lexington. So it's the same one that was provided in the notice of claim and the complaint, and that's the picture that was submitted that the client actually circled. There was a circle put around based on the client's statements so that it was clear to the city which intersection and which corner this was at.
So going back to a question that was asked by my colleague, does the fact that there's no traffic signs, there's no signage indicating what the street or avenue was, is that a problem?
There is a requirement to, and it is hurtful to the plaintiff's case or the appellant's case that there's not a street sign, but you can
There are
clear.
no street signs. There's nothing in any of the photographs that say 59th Street and Lexington Avenue, nothing.
But there's clear storefronts, and you can
You know what
easily
the
see
issue
their
is
address.
with storefronts? I was thinking about this. Now in the city, stores are going out of business, right? So we don't know storefronts anymore, right? What used to be an Express on 59th Street now would be a Bath and Body or something of that nature.
But 5 years after the
Yeah,
accident,
59th
that's a
Street and
problem.
Bloomingdale's.
But if this
Only
was investigated-
Bloomingdale's is the one that we would be able to see and we would know exactly where it was. But very interesting arguments.
If
Thank
this
y'all.
was investigated in a timely fashion, it's our position that, and Google didn't go out of business just because the stores may have, and it's really simple.
Yeah,
to
but
see.
Google Maps doesn't really help you. But thank you very much.
Thank you, Your Honor. Have a great day.
Take care. So we're back to the top of the calendar. People v. John Doe, AKA Renee Luna. We're just going to wait for Justice Gesmer to return.
Certainly.
Good afternoon, Your Honors. Katrina Jean Myers from the Office of the Appellate Defender for Mr. Rene Luna. Your Honors, this is a trumped-up robbery case. Mr. Luna is serving 8 years for stealing a $20 flashlight from Home Depot and allegedly displaying a hunting knife while he left the store.
Isn't this really, on that particular point, an issue of credibility that the jury would be able to decide? I mean, there were several different camera angles. The jury was free to look at those camera angles and then hear the testimony of the witnesses, and they can make the determination.
Your Honor, the only evidence of Mr. Luna's display of the knife, the threatened use of force that made the petty larceny rise to a robbery conviction, came from the store security guard, Jeffrey Griswold, and his testimony was not credible. It was directly contradicted by a CRC officer stationed outside the Bloomberg building who said that he told her that he was unaware that Mr. Luna was armed at the time of the theft. The jury likely misweighed the evidence in Mr. Luna's case because of defense counsel's ineffective assistance during the trial. Specifically,
On that point, is that reviewable at this stage?
Yes, Your Honor. Counsel made on the record mistakes that severely deprived Mr. Luna of adequate representation. Specifically, counsel allowed
Was there a 440 motion done in this?
No, Your Honor, there wasn't a 440 motion in Mr. Luna's case, as there is record proof of counsel's ineffectiveness here. Specifically, an officer, Andrea Terrizzo, testified that she heard that there was a weapon involved in the robbery at in the theft from Home Depot while responding to the scene of the crime. That statement was incorrect. An ICAD report indicated that a larceny was in progress and that no weapons were involved. Other than Mr. Griswold's testimony, this was the only additional piece of evidence that indicated that a weapon was involved in the crime, and it was inaccurate. However, this was brought to the jury's attention. In fact, the jury asked for it in deliberations because defense counsel failed to put the ICAD report into evidence to correct the officer's testimony. And defense counsel tried to do so on multiple occasions. He tried to get it in to refresh the officer's recollection, although the officer didn't say that she misremembered anything. The court then tried to help the defense counsel figure out how to get the evidence in. He didn't pick up on the hints. And in fact, at one point he said, "The spotlight is on me at the moment. I don't know what to do," and completely abandoned that line of questioning. That was not effective assistance of counsel, as the jury requested this piece of inaccurate testimony in their
But as my
deliberation.
colleague stated, we don't have a 440, so how do we make a determination as exactly what the attorney was referring to when he made these statements, and what exactly his, how he was proceeding with the defense?
I think, Your
I
Honor.
mean, again, I don't understand, without the 440, how do we know that this was not simply a trial tactic on his part? Or her part, I don't know if it was male or female.
Because counsel made multiple attempts to get this piece of information before the jury, because counsel's failure to do so lacked any strategic purpose whatsoever, because it allowed the jury to consider completely inaccurate information that was detrimental to Mr.
And how
Luna.
was this, I wanted to get back to something you stated before. I thought that Griswold told the officers outside that the defendant had a knife when he was in the store and took the flashlight.
Mr. Griswold told the CRC officer stationed outside the Bloomberg building, according to his testimony,
Yes.
that Mr. Luna had the knife. However, that was directly contradicted by the officers.
How is it directly contradicted by the officer?
The officer who detained Mr. Luna,
Is that Frisk or the other one?
it was
Yes.
Officer Fayez.
Baez.
Officer Fayez asked Mr. Griswold why he did not tell her that Mr. Luna was armed.
Yes.
Because she was unaware. She drew her weapon to detain him because she was unaware
And how
that
does
Mr.
that
Luna was
directly
armed.
contradict whether the defendant had a knife?
Because Officer Fayez told the jury that Mr. Griswold said that he did not tell her because he was unaware that Mr. Luna possessed a weapon during the theft.
Go ahead.
Wasn't Mr. Griswold's testimony corroborated by the fact that when they eventually stopped your client, he in fact had a knife on him?
Mr. Luna did have a knife at the time of his arrest, but there is no corroborating evidence that Mr. Luna displayed it during the course of the robbery,
Other than the testimony by Mr. Griswold.
which was the only evidence that Mr. Luna displayed
And
the
so this
knife
is how
in
we
the store.
started out. How is that not an issue of credibility for the jury to make a determination?
It is an issue of credibility for the jury to consider. However, the jury misweighed the evidence in Mr.
So the
Luna's
jury
case.
is now presented by testimony by Mr. Griswold that the defendant had a knife at the time of the robbery and the taking of the flashlight. And the jury is presented with testimony from Officer Fayez and the other officer that when stopped, the defendant had a knife on his person after he exited the Home Depot and was ultimately stopped. So why then could the jury not make a determination that the defendant did in fact have a knife during the course of the robbery?
The jury certainly could have reached that determination.
And they did.
However,
They did, right?
they did. However, their determination was impacted by inaccurate facts that were put before them due to defense counsel's failures. Specifically, the false statement from Officer Terrizzo that she was responding to a radio run that indicated that weapons were involved.
So again,
That
we're
was not
weighing,
true.
so the jury is weighing all of the evidence, and in this instance, they weighed the testimony of Griswold, Fayez, and they weighed the testimony of the other officer who stated what she was responding to, and they made a determination that it was sufficient and proof beyond a reasonable doubt of the robbery.
However, the third officer that you're mentioning, her testimony was factually inaccurate. There was an ICAD report that directly contradicted what that officer said. The jury should not have had that in deliberations to reach a verdict, and it was there because of defense counsel's failures. And that was not the only failure that defense counsel made that negatively impacted Mr. Luna's chances of a fair trial. And if I
We can
redress-
discuss those on rebuttal.
Thank you, Your Honor.
May it please the court, my name is Patricia Curran and I represent the people on this appeal.
Ms. Kern, could you start with that? Could you respond to that portion of your adversary's argument concerning was it an I-card or whatever it was?
It's called an ICAD report, Your Honor.
ICAD report.
And defense is criticizing the form of the questions that the defense attorney asked Officer Terrizzo about the ICAD report. However, it is clear from Mr. Griswold, who testified after Officer Terrizzo, that the ICAD report, which was of no moment really anyway, would not have made a reference to a weapon because Mr. Griswold said he did not call 911 and he did not tell the traffic officer, who apparently called 911, that the defendant had a weapon. Officer Terrizzo said that the ICAD report was based on the 911 call. So it should have been no surprise to the jury that the ICAD report did not mention a weapon. Obviously, Officer Terrizzo was mistaken that she relied on the ICAD report in knowing ahead of time that the defendant had a weapon, because she also testified that she heard over the radio from the CRC officers that the defendant was armed. So yes, Officer Terrizzo made a mistake in her testimony, but that did not mean that this defense attorney, who did a wonderful job in the situation.
We'll get to the defense attorney in a second in terms of the ineffective assistance of counsel. Was the jury made aware of the inconsistency and the error in Officer Terrizzo's testimony concerning the ICAD report?
You mean were they directly made aware?
Well, I mean, did they hear the testimony?
Well, they heard the testimony of Mr. Griswold, who enlightened them.
So did counsel argue as to the inconsistencies during his summation?
He made all these arguments about the inconsistencies in the testimony, and the jury obviously credited Mr. Griswold by their verdict convicting the defendant.
And did he cross-examine Officer Terrizzo as to the inconsistencies in her testimony?
Do you mean about
The ICAD.
the ICAD? He certainly asked her questions, and the court corrected him as to the form of his questions, but that's, the form of his question should not result in a finding of ineffective assistance here.
Okay, what about your colleague, your adversary's statements that at some point in time, defense attorney made a statement, I don't know how to get this in and was given hints by the judge in terms of how to introduce whatever piece of evidence. I guess that was the ICAD report.
Well, Your Honor, that doesn't mean he was ineffective. I mean, there are many ways that a defense attorney can relate to a jury, and simply saying, well, I'm on the spot now, doesn't mean he was ineffective here, and certainly as to that one single issue.
So you're saying it could have been strategic as opposed to showing incompetence?
I'm sorry, Your Honor, I
So
can't.
you're saying it could have been strategic instead of a showing of incompetence?
Well, it could have been, certainly. I mean, defense attorneys certainly are known to have relationships with juries by their performance. I don't think that this was particularly unusual, no. Certainly, given the testimony here, it should certainly not persuade this court that this lawyer was ineffective, particularly because there's no 40-40 motion here. Now, I want to just talk a moment about defense counsel's arguments about the weapon. What Officer Fayez actually said was that afterwards, excuse me, afterwards, she asked Mr. Griswold why he had not alerted the CRC officers that the defendant had a knife. And his response, according to Officer Fayez, was, well, I don't know. Well, it's not clear what that really means. This was a fast-paced incident. What happened immediately when Mr. Griswold followed the defendant out into a busy midtown street. He testified that he alerted the officers that the defendant had a knife. They simply may not have heard him in trying to deal with a defendant who suddenly took out a knife and displayed it to them. But the corroborating evidence here is clear. The defendant had a knife and was ready to display it to the officers when he left the store.
And did display it.
And did display it readily. And the fact that the clips of the surveillance tape don't show that simply means that the tapes were clips. There was no indication that they were a continuous movie of everybody in the store based on these cameras. So they did corroborate the...
I mean, but there were 50 different angles, right?
They were from different angles throughout the store, and the clips that we sent to the court certainly partially corroborate Mr. Griswold's testimony because they show the many parts of the encounters, but they were never meant to be a continuous movie of every action that the defendant made in the store. I see my time is up. If anyone has other questions about either the statutory presumption or the ineffective assistance of counsel claims, I'd be glad to answer them.
Thank you.
Seeing none, thank you.
Your Honors, if I may first address respondents' contention that the ICAD report was of no moment. Again, this was the only additional proof that Mr. Luna allegedly displayed a knife while in Home Depot, and it was inaccurate. According to Officer Trevizo, Mr. Griswold made this statement immediately after he left Home Depot. It was while it was fresh in his mind and the first words that were uttered out of his mouth after the incident, if it were to be believed. It's hard to believe that the jury would not have credited that testimony and would not have taken it into consideration. In fact, the fact that the jury requested Officer Trevizo's testimony during deliberations is indicative of the relatively weak weight of the prosecution's case. Mr. Griswold did not provide credible testimony. His statements were not corroborated by the surveillance footage in terms of whether Mr. Luna displayed the knife within the store. The only proof was his testimony, which was filled with inconsistencies. And every time he made an inconsistent statement, he provided the court and the jury with an explanation that was implausible, that the court reporter got something wrong, that the police report was wrong. Even when he was questioned about surveillance footage, he said that there was surveillance footage that existed from the mezzanine level of the store that showed Mr. Luna displaying a knife that was not entered into evidence. And the prosecution made a record to the court indicating that this piece of evidence was not in her possession, that she reviewed the footage with her intern present and Mr. Griswold prior to trial.
I guess the question that I have, because you're making very good arguments and whatever arguments might have been made below, but wouldn't that still require us to now put ourselves in the place of the jury and say, well, this witness wasn't credible, as opposed to the jury hearing all of that and making their determination?
Your Honor, the jury was able to hear all of that, but the jury also heard improper, incorrect, inaccurate information because of defense counsel's failures, including testimony about that video that was not entered into evidence, that was not examined by the defense or the prosecution. And the prosecutor put it on the record that Mr. Griswold told her before trial that she had all of the video evidence. That just simply wasn't true. The jury never got to hear the prosecutor's explanation because of defense counsel's failures, and instead the prosecutor used Mr. Griswold's statements during her summation to argue that there was additional footage that may have existed, that Mr. Griswold simply misremembered, that wasn't absent because of some sort of mistake. That was a direct contradiction of what she told the court and what Mr. Griswold testified to.
Thank you. Thank you very much.
Thank you, Your
Gilman v.
Honors.
State of New York.
Good afternoon, everyone. My name is Peter Traub from Stevens & Traub, and I represent the appellants. We believe the appellant's motion for summary judgment should have been granted as a matter of law. And we also believe that the governmental immunity doctrine has no place and no role in this analysis.
And so how do we get around the Court of Appeals decision in McLean versus City of New York, which it seems to me is, I'm having trouble understanding how you're getting around that to argue that we should find in your client's favor.
Well, you're talking about the governmental immunity analysis, which does not apply to ministerial acts. And so the state, we maintain, is under an absolute obligation to create a sex offender profile, according to the statute, in the name of the sex offender. That's a ministerial act. That's a ministerial act.
Counsel McLean says that a ministerial act may be a discretionary, may be treated as a discretionary government action to the extent that there's no basis for liability if there's a violation of a special duty. So we go back to the old special duty analysis. What special duty was owed to your client here?
Well, I disagree that in this case that applies. If the state has a ministerial duty to do a thing and it's mandatory, there's no discretion involved in this, then that duty must be complied with by the state. In this case, Kevin Tillman never sought out a government function. He didn't ask the government to do something for him that they didn't do. The state went out of its way and defamed him by publishing a sex offender profile in his name. And
So back up 1 second. So we know that the corrections law says that aliases may be included on the website, right?
No.
As a subdirectory.
No.
It's correction law section 168-1 sub 6 sub B. Aliases may be included in the subdirectory.
That's a 168B profile. The SORA creates several different types of profiles, and each profile is specifically delineated as to what it may contain. A 168B profile, which contains everything, including aliases, nonetheless is not allowed to be disseminated to anyone outside the group of listed entities contained within 168B. When you get to the internet profile, the legislature specifically listed what may be included, and what they didn't include was aliases, which of course raises...
So in this instance, we do have an asterisk talking about the aliases, right?
Well, aliases we're talking about the second defamatory act right now, not the initial one, where for 11 years the state published a profile in the name of Kevin Tillman as the primary name on a sex offender profile.
But that was because his cousin used his name for purposes of when he was arrested and also for purposes of SORA.
Not with respect to the sex crimes.
I'm sorry?
Not with respect to the sex crimes. Jeffrey Washington was tried in his own name for the sex crimes. He was convicted in his own name for the sex crimes. He, in fact, appealed to this court twice in his own name for the sex crimes.
But then he ultimately used the name of Kevin Tillman.
While this case was up on appeal before this court, Jeffrey Washington robbed a lady of a purse on the street.
Yes.
And for the burglary charge, he used the name Kevin Tillman. But even during those proceedings, the court found out quickly he was Jeffrey Washington because they
Didn't he register as Tillman?
he signed his name as Kevin Tillman, which of course gets to the point, my God, the
Counsel,
state.
doesn't sign your name mean the same as register?
Sure. No, I don't dispute that Jeffrey Washington registered pursuant to the registration
That's what I
requirement.
said. I said he registered as he registered as Kevin Tillman.
I don't dispute that.
Okay, so if he
I do
registers,
dispute the sex crimes, though. The sex crimes he was tried under his own name.
it doesn't really matter because we're talking about the SORA registration. So for the SORA registration, we have Kevin Washington, AKA Kevin, excuse me, whatever
Jeffrey Washington.
Jeffrey Washington, AKA Kevin Tillman.
That's not how he signed it. No, he signed it Kevin Tillman. That's the
For the
registration.
purposes of the registration,
He was
Kevin Tillman is an alias of Jeffrey Washington.
Kevin Tillman is an alias of Jeffrey Washington. That's correct.
Okay, exactly.
Right. So Jeffrey Washington signs his name Kevin Tillman when he actually registers, but the respondent is aware, because of all these court proceedings, that the name of the
But
actual
the point is that when you use an alias, that alias travels with you. So whenever Jeffrey Washington comes up, it's going to be AKA Kevin Tillman.
correct.
I'm
And in fact,
wondering,
that's the sentencing
counsel-
order for the sex.
Counsel, I'm wondering if your argument is that because they knew that he was Jeffrey Washington for the sex offender crimes when he was convicted, when he went to register as Tillman, they should have been alerted that that wasn't what it was supposed
Absolutely.
to
In fact,
happen?
they were alerted because contained in the record are memos from the attorneys when this all came to light saying, we put in Jeffrey Washington's name, he has his prison number. We put in Kevin Tillman, who was homeless and selling things on the street, and so he got arrested. once
Okay,
he
so
was
counsel, where is your authority, or where is there any authority that you can point to that states when an individual uses an alias that the Department of Corrections, whomever, has to know that that's not his name, and that therefore we should not have that alias included on any of the documents or any of the paperwork for that individual?
Well, I'm not saying that they should not have Kevin Tillman as an alias for Jeffrey Washington with respect to one of the profiles, the 168B profile. What I'm saying, however, is that even 168 mandates that the respondent create a sex offender profile in the actual name of
So
the sex
you
offender.
wanted, so you're stating that the record should say Jeffrey Washington for the sex offender, for the sex offenses, and then it should say Kevin Tillman, Jeffrey Washington, AKA Kevin Tillman, for the burglary?
No, not at all, Your Honor.
So we would, what?
That's not what I'm saying.
So I'm trying to understand, I'm sorry.
Sure.
So given the fact that Mr. Washington used the name Kevin Tillman, and therefore Kevin Tillman is an alias, you're stating that that should not be on any paperwork related to Mr. Washington?
Not at all. I'm not even coming close to saying that. What I'm saying is that for the purposes of creating a sex offender profile, you must put it in his actual name. And the state knew it was Jeffrey Washington, not Kevin Tillman. Within that profile, for a 168B profile, you have a section.
And you're stating that
If you've been to the site, you'll see each profile has a section, aliases. Kevin Tillman could be listed there.
And so the state
for a
came
168B
upon,
profile.
the state would have come upon that information that it was actually Jeffrey Washington and not Kevin Tillman because of the litigation that was taking place?
My God, they had 5 orders, sentence commitments orders in the name of Jeffrey Washington for the sex crimes. They had 2 more afterwards. They had the order from Judge Moore that directed he was a level 2 sex offender in the name of Jeffrey Washington, AKA Tillman. They also had an appeal to this court and a writ of habeas corpus.
So they should have
in federal court.
rejected, so they should have rejected the alias of Kevin Tillman.
Not rejected it. They should have realized that this is not Kevin Tillman. Let's not create a profile in the name of Kevin Tillman. Let's
Any
create it in the
authority?
name of Jeffrey Washington.
So again, any authority which would give that, which would state that the state has that obligation?
168B, the statute. The statute states quite clearly the state shall, not discretionary, shall create a sex offender profile in the name of the sex offender. Included within that profile will be a description, a photograph, any aliases used. Nothing in the statute permits the respondent to create a sex offender profile in the name of an alias of Kevin Tillman. In fact, no other state in the country does that.
Thank you. You have time on rebuttal.
Thank you.
May it please the court, Assistant Solicitor General Kwame Akosa for the state of New York. Just to be
Counsel, I just have a question, just picking up on where your adversary left off. So it seems to me that the issue here is that because Mr. Washington had been convicted under the sex crimes as Jeffrey Washington, when he went to register his sexual offender profile and used the name Tillman, that's where the error occurred. Even though maybe Tillman could be listed as an alias, it shouldn't have been the profile that was created. So I'm wondering, does that border on gross negligence or some other standard?
No, Your Honor, it doesn't rise to gross negligence at all here because all the agencies involved in determining the name followed their internal operating procedures. My friend did not mention the fact that the Department of Correction here has a system for determining what the name of the inmate is once they've received the court documentation and the commitment order. What happened here was that when Mr. Washington was convicted of the burglary charge, he held himself out as Kevin Tillman and was tried and convicted as Kevin Tillman. And because the Department of Correction had a record for Kevin Tillman, when he was let out in bail for that burglary charge and committed the sex crime and identified himself as Jeffrey Washington and was tried and convicted for that crime, he was brought back, he was remanded back to the Department of Correction, and the Department of Correction's policy is that if we have two documents listing two different names, we follow the document that was first given to us, the earlier document, not the later document. And so what happened here is when he was incarcerated for that sex crime under the name Kevin Tillman, in the Department of Corrections system, he registered as a sex offender and the name Kevin Tillman was on the registration form, and he signed his name Kevin Tillman. And he continued to sign his name Kevin Tillman annually as he's required to do so as a level 2 sex offender.
So here, if I'm correct, the conviction for the burglary, for the attempted burglary was 1995, right? Mm-hmm. And Mr. Tillman discovers the error in 2019.
Correct.
Right. So let's assume for the sake of argument that we're not looking at the period from 1995 to 2019.
Okay.
And looking at the website and looking at the sex offender registry, that part of the website that says, by the way, an alias might just be an alias and it may not actually be the offender's real name. It is like about this big, whereas the aliases are much larger, maybe like 3 or 4 times as large. Why don't you have a duty to make that distinction clear that, why not? We understand that the purpose of SOAR registration is to protect the public, okay? Why not protect all of the public, including those people who come under the aegis of being an alias?
Well, Your Honor, the special duty requirement has to come first before we assess the reasonableness of the state's administration of the Sex Offender Registry Act. So, and it's not enough just to say that the state owed a generalized duty to the public that was also owed to Mr. Tillman here. There has to be a special duty owed to Mr. Tillman, and there hasn't been anything like that shown here. So Mr. Tillman has primarily argued here that the states did not comply with the statutes governing the Sex Offender Registry Act, and that's the basis.
I guess what I'm asking you is don't you owe a duty to the public to be accurate?
Absolutely, Your Honor. So perhaps a member of the public, that was in some way harmed by the But so in other words, the sex offender registry online is intended to give the public information they need in order to be aware
And
of the
here
dangers.
that information was used by an agency to determine that Mr. Tillman was not eligible for subsidized housing, right?
That's correct. So HPD notified Mr. Tillman that it appeared that his name was on the sex offender registry, and they gave him information about how to resolve that matter. He immediately went to the Department of to DCJS. They took fingerprints within weeks. His name was removed from the registry, and he was given a memorandum.
We're in 2024, and right?
Yes, I'm sorry.
And the registry might be considered inadequate in terms of providing clarity as to what an alias really means.
Your Honor, the legislature has made a determination here that aliases are essential for public safety, and so
I'm not arguing that with you at all. I'm saying that there's a way in which to present information that meets a really great need.
there may be a better way to present the information, but that's not the question in this negligence action here. So the first and foremost here is that there needs to be a special duty owed specifically to Kevin Tillman based on a statute or some assumption of a duty by a governmental official. And there's been no allegations here or no facts or evidence here to make that showing here.
So what you're saying is that Mr. Tillman has no remedy, right?
Well, Mr. Tillman has no remedy against the state for this particular alleged negligence. So he may have a claim against his cousin, but this is not something that he can hold the state responsible for unless he can show a special duty. And to be clear, there's some arguments here he's been making about how the sex offender subdirectory is not required to show aliases. That's just not correct. So Corrections Law 168L requires DCJS to disclose the aliases on the subdirectory.
Oh, yeah, I'm sorry. I said 168, one before, but it is an L.
It is the L, yes, correct, Your Honor.
So I want to be clear. The argument is that, well, my question is, would you have the ability, absent legislation, to not include that alias?
No, Your Honor, no. The alias is required to be disclosed under 168L and 168Q.
And so the argument was that the state knew that his name was actually Jeffrey Washington and not Kevin Tillman, and so therefore Kevin Tillman, that name should not have been included as an alias.
Well, Your Honor, we would dispute the argument that the state knew that his name was Jeffrey Washington.
Well, he said there was a memo from Judge Moore, there was the litigation, et cetera, so you knew that the name was Jeffrey Washington.
What the state knew at the time was that when he was incarcerated, his name was Kevin Tillman, and when he registered as a sex offender, his name was Kevin Tillman, and when he continued to register as a sex offender, his name was Kevin Tillman. So those were the procedures.
Was there any information that the state had that, in fact, Kevin Tillman was Jeffrey Washington for sex offender purposes?
Not to my knowledge in the record, Your Honor, no.
Not his convictions?
Well, I'm sorry, his convictions did not inform the registration. The convictions were the basis for his name when he was incarcerated, which then, as I mentioned earlier, the Department of Corrections has this policy where if you have two names, the Department of Corrections will incarcerate you based on the first name that they've received. And so the state is not on notice that one of these names is the correct name.
I'm just wondering, that doesn't make sense, because then Jeffrey Washington, presumably who is the sex offender, is not registering.
Jeffrey Washington, so it's correct that the sex offender registration that was provided incorrectly stated that the name was Kevin Tillman and the alias was Jeffrey Washington. The reverse was true.
But it's more than incorrect. It was done on purpose. I mean, it's not like the state made a mistake as to Mr. Tillman. Originally, the mistake is due to the cousin scamming the system.
That's correct,
right?
Your Honor. Yes, Your Honor. Yes, it was done intentionally by the cousin.
So I understand that there could be a public purpose in saying, hey, public, this name may continue to be used to scam you when the real person is the cousin, okay?
Right.
But on the other hand, looking at it from Mr. Tillman's point of view, what you're saying is that as to protecting himself from being pulled into a similar scam going forward, he has no protection.
Your Honor, he had the protection in the sense that he was able to go to DCJS and have the matter resolved expeditiously, as occurred here. He received a memorandum which was used to obtain the public housing that he requested.
But it doesn't assist him in the future, because it can come up again in the future if he applies for a position or if he applies for public benefits, right? It's still gonna show up that he's a registered sex offender.
No, it will not show up, Your Honor, that he is a registered sex offender. It will show up that Mr. Jeffrey Washington is a registered sex offender and had used the alias Kevin Tillman, which is undisputed. That name is forever will be associated with Jeffrey Washington because he in fact used that name and committed crimes and was incarcerated under that name. And that is a basis for the agency has no discretion
So
here.
if I go on the internet and I look at the SORA registrations in my neighborhood or wherever Mr. Tillman lives, it's not going to show Kevin Tillman.
No, Your Honor, it will show Kevin Tillman because that's an alias associated with Jeffrey Washington.
And so
that's our
know-
point.
Okay.
So is there any way you can delete Kevin Tillman from the database?
No, Your Honor, there's no discretion here because the agency has to disclose the aliases associated with the sex offender.
So one of my 40 cousins can take my name, commit a sex crime, and I'll be on SORA?
No, Your Honor. It's not so simple as someone just claiming this is their name. This is a situation where the individual was tried and convicted under Kevin Tillman, and it's associated with that.
But not
I'm
as
trying
the
to
sex
understand.
offender. But
I'm
not
trying
as the
to-
sex offender. He wasn't convicted as Kevin Tillman. He was convicted as Jeffrey Washington. I mean, I just don't understand because without Mr. Tillman going because he didn't get housing, Jeffrey Washington would never have been registering.
And free to commit more crimes.
Well, Jeffrey Washington was listed on the sex offender registry as an alias of Kevin Tillman.
Counsel, please make me understand.
No, so wait.
Jeffrey Washington is convicted. He goes to register. There's no paper there to show, who are you, Mr. Tillman, because you didn't commit a sex crime?
I'm sorry. Could you repeat
So
the
wait,
question?
you're saying that when he committed the sex crime and when he registered as Kevin Tillman and not Jeffrey Washington?
Correct. When Jeffrey Washington registered as a sex offender, he registered as Kevin Tillman. That's correct.
When he was arrested, was he convicted as Kevin Washington or was he convicted as Jeffrey Washington or as Kevin Tillman?
Both, Your Honor. So first it was Kevin Tillman for the burglary and then for the sex
We're
crime.
talking about the sex offender crimes here, counsel. I understand you want to bring up the burglary, but that's not the issue here because burglars don't have to register as sex offenders. Sex offenders have to register as sex offenders.
When he's arrested on the sex offense, right? What is the name that he is arrested under?
Jeffrey Washington, Your Honor.
Jeffrey Washington. Then he is released on the sex offender on the sex charges, right? Is that correct?
Well, he's incarcerated.
He's
in relation to the release,
incarcerated,
correct.
and then for the SORA, when he's filling out the paperwork on the SORA,
While incarcerated.
he then states that his name is Kevin Tillman.
Correct, Your Honor.
Okay, so now the paperwork is going to say Jeffrey Washington, AKA Kevin Tillman.
The paperwork will say Kevin, well, in fact, the paperwork said Kevin Tillman, AKA Jeffrey Washington.
Why, when he's filling out the paperwork, why isn't he told that's not your name, put Jeffrey Washington?
Because the name that was listed for him was Kevin Tillman at the time he was incarcerated.
So
But
counsel,
at the time he was arrested and convicted, he was using Washington.
Correct.
So why is it that if that was the name he was convicted under, he was permitted to register as a sex offender with a different name? Why didn't the Department of Corrections say, hey, you can't register under that name, you have to register under the name you were convicted under?
Okay, well, when criminal defendants have multiple aliases or multiple names associated with them, there's a policy that's put in place to make a determination about what name
But
to
counsel,
use.
wasn't this the first
Gotta
time
change
he
that
used
policy.
it? Was this not the first time that he was using the name Kevin Tillman?
With respect to the registration of the sex offense?
Yes.
Was this the first time he used the name?
Yes.
That is not correct. That was the first time he used Kevin Tillman. He held himself out as Kevin Tillman previously when he was.
So-
I have to mention it, but it was during the initial criminal
The
conviction.
burglary?
When he was registering for the sex offense, why is it that the Department of Corrections didn't say that's not the name which you were convicted under for a sex offense? I would think that would be the name that would come first, and anything else would be an alias instead of the other way around. I'm having trouble understanding why this is your policy.
Well, Your Honor, the policy is set forth in the record, and it says simply that when there's a process in place just to figure out what the person's name is. The agency is not necessarily on notice that one of the names is an alias and one of the ones is is the actual name. So
But if he's
I wanna move
convicted
to the
under no one
present.
name and registers under another name, then they're on notice.
they are on notice. You're correct. If that,
So at that point, why doesn't the agency do some investigation so that they make sure the right person is listed? Because the public has an interest in making sure that the person who's actually a sex offender is the one listed as a sex offender.
well, Your Honor, with respect to how the registration form is evaluated, there is a process for checking the entries in the form against the registrant's criminal history. And there was some testimony in the record that that's the normal process, but there was no testimony in the record about how that was done with respect to Kevin Tillman. But there is a process in place for evaluating the information that is contained on the sex
So I
offender
want to move
registration
to the
form.
present day and going back to how the website presents information. Surely there is a way, is there not, in which the website can reflect the fact that Kevin Tillman is not the name of the perpetrator. Surely there must be some way to alert the public that if this name comes up as an alias, that this is not the perpetrator who was convicted. There are so many ways to design a website. There's so many different ways to do it. This is terrible. It's terrible for the public, it's terrible for government, and it's terrible for the individual who's the victim.
Well, Your Honor, as I mentioned earlier, there might be an alternative means of designing the website, but that's, on this case, though, we first need to start with...
Right, but perhaps you can bring back the concerns of this panel, because everybody here appears to be consternated about this situation. And special duty, it doesn't fly. It doesn't go far enough.
So you're saying it would be a legislative, the legislature would have to make a determination in terms of redesigning the website, or is it on the Department of Corrections or SORA to redesign the website?
Well, Your Honor, the legislature certainly could require the aliases to be presented in a different way, absolutely. And the agency, obviously could design the website in a different manner.
But you don't need legislation, do you, in order to design or redesign a website?
Well, Your Honor, if you're referring to when an individual types a name specifically in, and it gives you a...
No, I'm not talking about that. I'm talking
Yeah,
about
you're
design.
talking about when the person types a name into the website, it's going to come up as Kevin Tillman, right?
Yes, Your Honor, yes.
And so as opposed to that little statement there, an offender may be on this list multiple times due to aliases that were reported by the offender on his or her registration form. The question is whether, as opposed to that, there could be some other indication as to the fact that this is an incorrect name.
Well, Your Honor, we would dispute the idea that this is an incorrect name. It's a name that is associated with the
So the only question is whether or not the agency would have the authority or has the ability to change that little asterisk and that note and state something else.
Well, Your Honor, yes, absolutely. The agency could say something else in that asterisk. And just to clarify, on the actual offender profile, it does list Kevin Tillman as an alias.
Yes, yes.
Yes.
Yes,
So,
but he's also on the National Sex Offender Public website.
right. Yes, Your Honor.
I mean, come on. Do you really need legislation to improve this?
Well,
I mean, you don't have to answer that. That is a rhetorical question, but.
Thank you.
thank you, Your Honors.
Very briefly, Your Honors, my time ended when Your Honor asked me a question about authority. We cited Lapidus versus State, which we think is the most analogous
So
case.
what did you move for? You moved for what? That
Summary
his
judgment.
name be stricken? His name be stricken from the registry?
No, the action is for damages as a result of defamation of character, which of course has destroyed the appellant's life. But in particular, we move for summary judgment. But the authority is Lapidus versus State, where in a court proceeding, the wrong name was put on an order, and as a result, an unfortunate young woman was sentenced to 5 extra years in prison. The Court of Appeals held no governmental immunity, no special duty necessary. This was a pure ministerial act that was actionable in ordinary negligence. So that's the authority in terms of case law we support. In terms of some of the questions, just so the court is aware.
The questions seem to be concerned with where do we go going forward. And also, how does this type of situation not occur in the future? But and it's clear that his name continues to be listed as an alias, and it's going to be continue to be listed on the registry. But you're not moving. You did not move or seek any deletion of the name from the registry or anything like that.
Well, we actually took care of that pre-litigation when we had the profile change, but that's all we were allowed to change in the proceedings. The court was asking questions before about the state's ability. You don't need legislation for this. We deposed New York State's chief IT guy who designed the system. And he said, I designed it this way because that's what they told me to do. And if you want me to change it so that I can do it like every other state and the federal government does it, it's a simple computer reprogramming. You type in the name of an alias, it takes you directly to the actual sex offender profile.
But was that request made and therefore to be done by the agency?
I have not brought a declaratory judgment action asking them to do that. I'm seeking damages. This is a defamation case.
Perhaps.
Well, we still may do that in the future. We have to deal with the federal government.
If you wish to deal, I would think that you'd want his name deleted from the registry.
Well, we do, Your Honor.
Clarification made that was significant.
Right.
We also maintain that the internet profile, again, by the legislature is much more narrow and does not include aliases. This problem wouldn't exist had they just followed 168Q.
Well, again,
168L does not change that because 168LB creates 3 different subdirectories.
you still have to deal with McLean, which is how we started out this entire conversation. You still have to deal with McLean. And even if it is ministerial and not discretionary, you still have to show that there's a special duty owed to Mr. Tillman.
Well, we submit, Your Honor, that a duty is owed. If you want to use the nomenclature special duty, once a state goes out of its way to harm a citizen, and that citizen didn't ask for the state assistance,
You're assuming
duty
that the city
applies.
went out of its way. The city just,
Well,
the Department of Corrections followed its normal procedure. They didn't go out of there, didn't choose.
No,
to
bad
go
choice
after
of words,
Mr.
Your Honor.
Tillman.
Bad choice of words.
Right, and
When the
that's
state
why under
intrudes
McLean,
of its own accord into a citizen's life. For instance, the classic example is with an ambulance. I call for an ambulance, the ambulance doesn't arrive in time. That's governmental function. But if that ambulance
Counsel,
along the way strikes a
we
pedestrian,
are well aware of what the case law states.
Right.
The issue is whether there is a special duty owed to your client.
I
That's
submit
the
special
issue.
duty is not necessary when the governmental immunity doctrine does not apply.
I submit you should read McLean again. But thank you. Thank you both. Very interesting. De Silva versus Toll.
Good afternoon. May I begin? Sorry.
Yes, please.
Good afternoon, Your Honors. May it please the court, I'm Lisa Como for the plaintiff appellant. It's our position that while the Supreme Court was in large part correct in its analysis of the labor law issues under 240 and 241-6, it erred when it concluded that there were questions of fact with respect to whether or not there were, in fact, devices, particularly a material hoist, available to the plaintiff at the time that the accident occurred. It's really undisputed on the record that it was improper to be moving the form up the stairs manually.
So, counsel, both the experts agreed that a hoist was needed to.
The witnesses agreed. I don't think there's.
Yes,
yeah.
but the Nardella affidavit is silent as far as the plaintiff's allegation that he was directed not to use the hoist in carrying with that person, the foreman, Mr. Nardella, a 200-pound staircase mold up the stairs.
And they point to that sort of silence, if you will, as creating an issue of fact. It seems from Mr. Nardella's affidavit that his reason for not using the hoist was because...
No, not what it seems. Where's the rebuttal? Where's the rebuttal to the plaintiff's allegation? Huh?
You're representing
the plaintiff.
Plaintiff.
Ay. Did I get it backwards?
Yes, she's representing the plaintiff.
You know, the prior argument was so interesting, I don't even know what I'm saying either.
Yeah, so, yes.
I'm sorry.
Go ahead. I'm sorry, continue.
Yeah, so right, there's no question on the record that a hoist was needed, and they point to Mr. Nardella's affidavit. They want to use it in their favor, and they say, well, he was silent. He doesn't affirmatively state that he instructed the plaintiff.
Was there any rebuttal to your client's allegation that he was directed not to use the available hoist?
Not at all, Your Honor. He clearly stated in 3 different places in his deposition that he was specifically instructed by Mr. Nardella. It's undisputed that Mr. Nardella was his foreman.
And Nardella is the one who's carrying the 200-pound staircase mold. He's the one who's carrying it with him.
They're carrying it together. I think
carrying it
Nardella's
together.
at the top.
And they're going up.
Going up.
Right.
They're going up, plaintiff supporting the weight at the bottom as they're trying to maneuver around this pole, this
Right,
vertical pole
it
that's in
falls.
place to hold the newly poured concrete. It hits the pole a couple of times, and he falls, he loses his footing on the debris that's there.
What about the argument that this is just a slip and fall on debris and has nothing to do with elevation?
Right. I think that there are a number of cases cited in our brief that clearly refute that contention. A very recent case called Caba, which we cite at page 4 or 5 of our reply brief, 213 AD 3rd 520. It's very, very much like this case. I think they might have been going down instead of up, but it was a situation where there was some sort of freight elevator or hoist available. There were actually 2 at the building in that case. Turns out that at the time of the accident, they waited for half an hour for the only one that was actually running that day to come. It didn't come, and the foreman said, you know what, we're not going to wait. We're going to go ahead and hoist this manually. Absolutely was held to be a 240 case. Same thing in the Agley case, where they're going down an exterior set of steps with a heavy piece of equipment, and the plaintiff, he claimed that he slipped. There was some dispute over the testimony whether he really slipped on debris or no debris, but the court held plaintiff's entitled to 240. There's no question that he fell due to an elevation hazard, due to the absence of equipment, and in that case, they were prevented from using an elevator which was actually rigged and that they could have used because the building personnel told them not to.
Would you agree that if there's debris and someone falls while in an elevation, that there's still a good 240 claim?
Absolutely, Your Honor. I don't think there's any case law that says that when you clearly have a fall that is, I mean, it only has to be occasioned in part by the absence of a safety device. But here, I think it's clear he was hoisting it up manually. It's very heavy. Everybody agrees they shouldn't have been doing it that way. He's trying to maneuver it. There's nothing to support it. He's bearing all the weight on the bottom. He's hitting the pole, trying to maneuver around the pole. And as he's trying to do that and he can't support the weight, and his feet are slipping on the debris that's on the staircase.
Argues in its brief that there's no significant elevation differential here.
Again, I go back to the Caba case, the Agley case, the Derschneider case, the Conlon case. They're all cited in our briefs, and particularly in the reply, I think I cite them all together in one place.
Thank you.
Thank you.
Good afternoon, Your Honor. William O'Connell for the defendant, Toll GC.
Counsel, I'm glad that your adversary brought up the Caba case because notably it was issued about a year after Supreme Court ruled on this particular case, but Caba seems to be on all fours, other than the fact that they were going down the staircase. In this case, they were going up. How do you distinguish that case, which is really one of the most recent decisions out of this department?
I can't. Caba is a difficult decision. I cannot distinguish it. I think it was wrongly decided. I disagree with the precedent. The entire other
Why bound by it if you can't distinguish it?
Well, there are other cases in this court that are on very similar points, and I think that they're the ones that should control. And also, Nicometti in the Court of Appeals is a little bit, obviously, a controlling issue about proximate cause, about whether it's an elevation-related, gravity-related accident, or whether it's not. And in fact, plaintiff himself in this...
So how is going up a staircase and falling not a gravity-related accident?
Well, it's no more of a
Because
gravity.
you're not going to be going up if you're falling down, right?
Understood.
Okay.
But it's no more of a gravity-related accident than Nicometti was and the cases that involved the stilts, where obviously that's a tangential relationship to gravity. But in those cases, if you recall, and Nieves and some of the others where they're stepping off ladders, there's a small tangential relation to gravity, but it's really about the stilts being on ice. And that's what caused the accident, not the elevation. The stilts were perfectly fine in that case.
Are you claiming that there are any cases subsequent to CABA that are inconsistent with it?
I am not.
So if that's our most recent precedent and pretty much on all fours, why wouldn't we follow it?
Because I think the court is missing that in Nicometti and cases like that, there's a distinction between the elevation-related hazard and the actual cause on the ground that's causing the trip. This was a trip and a fall on a staircase.
So you're saying if there's debris on a staircase, then the fall is not the result of gravity-related factors and only a result of the debris?
That's correct.
So
then
the
based on-
200-pound staircase mold had nothing to do with the fall.
Well, I'm saying that plaintiff said that it didn't have anything to do with it. On page 210 of the record, the appendix, when the mold moved prior to your accident occurring, did it cause you to withdraw the question? When the mold moved prior to your accident, did it cause your body to move? That wasn't a problem. It moved a little bit, but I've done this a bunch of other times. When you testified that you slipped on concrete and fell, when you were referring to the concrete, are you referring to the concrete debris or something else? Yes, the debris, the leftover of the cement. Which foot made contact with the debris before the accident occurred? Right foot.
So, counsel, you would agree that the industrial code at 23-1.7F imposes a duty upon a defendant, I'm just going to say a defendant,
Sure.
to provide us a safe staircase that's free from defects? That's in Vasquez from 2010.
Right. The code provides that you have to provide stairwells and a few other types of ramps, and if not, another type of available advice.
And
in
you
this
would
case-
agree that even though this is a permanent staircase, that it falls under the statute because it's an elevated work platform?
No,
Pursuant to Gorey, 2014?
I absolutely do not agree that this 240 applies to this statute. This is a permanent staircase. It was not the sole means of access to the upper floors. There's testimony in the record that there were other staircases and these other safety devices, a hoist, an elevator, and a crane that all provided access.
So then we get back to the fact that the plaintiff stated that he was told by Mr. Nardelli.
And that's what I've wanted to talk about. Okay. It's our position, obviously, that the best person to know whether the plaintiff was instructed would be Mr. Nardella. And he doesn't confirm that at all.
He doesn't, he neither confirmed nor does he deny.
That's correct. But what he does say is that we should have been provided devices, and that's why we were forced to go on the staircase, which is totally not true. Every other witness in this case said there were 3 other safety devices that could have been used. So it's my position, and it's the plaintiff's burden on his motion for summary judgment to eliminate all issues of fact on sole proximate cause.
Didn't Mr. Nardella eliminate the issue by not countering what the plaintiff alleged, specifically that he was directed not to use the hoist, but rather to go up the stairs with Mr. Nardella?
Well, I'm saying Mr. Nardella does not support the notion that plaintiff was instructed. Plaintiff needs the instruction to get out of sole proximate cause because there are safety devices all over at this site. He needs that, and that's why he's pushing so hard to prove an instruction. And we have Nardella, the best witness who could confirm that instruction.
Let me ask
he
you this
doesn't
question,
confirm
counsel.
Yes.
Assuming what you're saying is true, would that go to maybe some sort of contribution as opposed to supporting your argument that that goes to sole proximate cause?
Your Honor, the way I would prefer to put it would be it goes, in this case, to the burden on summary judgment, which is what we're discussing here. And plaintiff had the burden. I moved for summary judgment. I filed a notice of appeal, but I withdrew it because I
I'm
saw
sure you would prefer
tribal issues.
to focus on that, but I don't think you're answering my question.
Oh, okay. I apologize, Your Honor. Do you want to?
It's okay.
It's okay, thank you.
Thank you.
Your Honors, I don't actually have that much to add, but if there are any particular questions, I'll be more than happy to address them.
No, thank you very much.
Thank you very much.
Carpenter versus 210 West 35 LLC.
May it please the court, my name is Brian Shute. I'm here today on behalf of Oliver Carpenter. My adversary correctly notes, as this court already knows, that when a landlord cedes control of a premises to the tenant, generally that landlord's not responsible for condition of the premises, absent a quote-unquote structural condition which is violative of a regulation. Of course, as the word generally connotes, there are exceptions. We submit the two of them obviously apply, that this relates to a mode of egress, and that was caused in part by the defendant owner itself. But let me start with the structural condition. We submit there was plainly a structural, within the meaning of the term of art that this court has defined, a structural condition that was violative of a specific regulation.
My problem with that, counsel, is that if the plaintiff had stepped out on the terrace and fallen from the terrace, I could understand your argument. But he didn't just step out on the terrace and fall from that. He stepped on the terrace and climbed over something else and then climbed up another level to get to the scaffolding, and that's where he fell from. So he engaged in, I guess what we would call intervening and superseding acts that really had nothing to do with the structure.
I think Your Honor's question flows from a perception that's created in the respondent's brief that.
Well, actually, I would have thought I would have described it as flowing from the facts as we know them, but go ahead.
And the perception is that actually there was an easy way to the fire escape, but my client didn't take it.
So,
my client
counsel,
went in a different direction.
I'm sorry, repeat that? The perception is?
The perception is that there was a way down to the fire escape, but my client chose not to take it and chose to instead.
Here's the problem. The fire escape is there obviously in case of an emergency, right?
Right.
And the video shows very clearly that the plaintiff was on the first floor drinking with the buddies and went upstairs to a second floor where there was nobody and nothing but lovely tables set up for dinner or lunch or whatever they wanted to eat up there. But it was completely empty, at which point he takes it upon himself to open the window, go out the window, go up the fire escape, jump over a guardrail, onto the shed, and then very tragically, he falls and he gets really, 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 really hurt. What does that, I mean, believe me, the situation is so tragic that one looks at this and says, is there any case for the plaintiff here? But temporary certificate of occupancy, the structure of the building, the shed didn't belong to the owner of the building here, the owner of the bar building.
Your Honor, both your questions, okay? The regulation states, fire escapes and access thereto shall be continuously maintained free from obstructions and impediments. Obstructions and impediments. Number one, the passage, the hole through which one has to go to get through the fire, to get to the fire escape, has been boarded up and nailed, 1356 to the record. But number two, and this relates to your question and the perception that my client went on some kind of a detour. Here's what he would have had to do to get to the fire escape, as opposed to the
escaping from a fire. He was just
Right.
he was just so
That's the
drunk that he
problem.
didn't know he wasn't leaving the building in the most efficient way possible. Instead, he was doing this bizarre thing.
You said a detour. A detour from what? What was preventing him from going out a door? I mean, you're saying it's a detour. So there's something that prevented him from going out the door of the James Sullivan or whatever, which caused him to have to go on to the fire escape, climb onto the shed, and then to the scaffolding?
We're dealing with proximate cause. There are at least 3 different causes of this accident. One, Mr. Carpenter is drunk, very drunk. 2, you have you use the term window. Other witnesses use the term door, but which positively invite people. One of the witnesses said that patron used it fairly often. And if he doesn't go through the door,
Fairly often to go out, I think, to smoke or whatever. That's one thing. But as my colleague said when we began, he didn't fall off the fire escape.
And that witness also testified that when people went to the terrace to smoke, management and staff would tell them to come back in. That was the one witness.
Yes. Your Honor, in terms of the blockage of the fire escape and whether, in fact, he should have taken a different route.
A different route to where? Where is he going?
A different route down from the terrace.
He was down.
But he was
on the
down.
first floor.
He started out on the first floor.
On the first floor.
And there was
Instead
nothing.
of taking a route out, he went up. That's not the usual way out.
That's why I said I did not understand your terminology for detour. You know, detour is road closed. You have to go this way.
We do not know for sure why he went up to the second
We
floor.
don't know that he had to puke and the bathroom was upstairs. That's not, I mean,
That was the theory.
that's not even here.
Well, actually, at pages 463 to 464 of the record, 2 of the witnesses, Benjamin Hadley and Joseph Mabley, said that they figured that he went upstairs looking for a bathroom.
Speculation. But you have time on rebuttal.
No, it is, but it is speculation, but
Yeah, you have time on rebuttal.
thank you, Your Honor.
May it please the court, Glenn Kaminsky with the firm Morrow, Lilling, the party, counsel for the respondent, 210 West 35th LLC. And we would ask respectfully that this court affirm the decision below. Truth is, you've addressed so many of the issues that I was going to raise that I don't know that it's necessary for me to raise them. I will say this. Plaintiff refers to 1027.7 of the fire code, and he talks about obstruction, but he doesn't read the whole regulation, which says that it has to be in relation to a fire or an emergency event in order for it to even apply. So there's not a violation, there's not a structural defect involved with a specific safety regulation that's even involved. It doesn't apply on its facts, and I refer you respectfully to the cases at 38 through 39 of our brief.
Was there a need to place some type of caution by the window, I'm going to call them egress windows. Was there a need to place some kind of caution saying, do not go through these windows, you know?
No. First of all, as the evidence and as the experts say, you can see through them. You can see what's on the other side. This is not a door that's you have to say not an exit. That's a solid door, and you don't know what's on the other side of it. You can see right through it. And so, no, you don't need to do that. Really, that argument is essentially plaintiff saying, hey, you owner, you failed to be an agent of good. Not that you really did anything wrong. And that's not the same thing, and that doesn't invoke liability.
Is the fact that the windows, I mean, like when you look at the windows, we've had different pictures. At the beginning, they look like windows that go up and down, right? Vertical windows.
Correct. Yeah.
Then you see that there's a latch.
Yes.
So is that a latch for purposes of egress, or is that an attractive nuisance, inviting people to come outside?
Well, I don't think it's a matter of fact, I think at 462 of the record, Mr. Hadley testifies that he sees the fire exit sign, the green fire exit sign that's there. It's to get to the fire, you're going to latch the window, but it's easily undone. It's not locked. I'm going to say, with regard to one of the many pre-World War II cases counsel cited in their papers, directed the court's attention to Levine Bowery 283 New York 497, the 1940 case, because it helps us, as it should. In that case, the court, in deciding that the fall from the fire escape created an issue of fact, they specifically say that the normal avenues of egress had been locked. That's not true here. You see in the record 1760 the photos of the red exit signs. You know the testimony that there's 2 ways down from the second floor. There was reasonable egress, ingress away. This was an unforeseeable and tragic event. But unless you have any questions, Your Honors, I'll rest on our brief.
Thank you.
Your Honor, in my very brief time, my 2 minutes left, I'd like to make 2 points. One, there's a long line of Court of Appeals cases, we cite Georgiarian as one of them, and other cases, that where you have a dangerous condition that brings about harm in an unexpected way, not the way you expected, that's not a defense because it's not the precise chain of events that has to be foreseeable. It's merely that this condition can lead to harm. That's what has to be foreseeable. 2, there is no question that this regulation was violated, not just that day, not just that week, not just that year, but for years on end. This is what one of the experts said. I read to you the regulation. Has to be free of obstructions and impediments. This is what one of the experts said was the correct way to get to the fire escape. If a person attempted to get from the platform to the second floor fire escape, they first had to get past the intermediate landing of the fire escape, the bottom of which was elevated 58 inches. There would have to duck and bend over to avoid bodily and head contact with that structure. After passing that intermediate landing—
Counsel, thank you for reading that, but my question is, are you saying that in order for the fire escape statutes to apply, that there and people gaining access to them, that there doesn't need to be some sort of emergency condition or some sort of fire? It's just that these fire escapes are there. People can just go, instead of going out the front door, can decide to use the fire escape to exit?
I cited 4 cases, Your Honor, that specifically involved fire escape, none of which were people fleeing from fires. One was my case in the Court of Appeals, Kelman, where, in fact, she was washing the windows from the fire escape. Another one was a cable splicer who's out on the fire escape cables, for his purpose.
Both of those people had actual reasons to be on the fire escape, unlike your client, who had no particular reason to be there, except that he was too plastered to realize he was there.
And in those cases, the injury occurred from falling from the fire escape, not climbing through the fire escape, to the shed, to the scaffolding.
Here, it was basically impossible to get to the fire escape because it had been boarded up. And yes, my client was negligent in going out that way, shouldn't have done so, but was it a cause? Could a jury find that one cause of him going out there is that you have a door that looks like it's a door to the exit and other people have used it? Could a jury find that was a proximate cause, a concurrent cause, along with—
Now, it might make sense if he hadn't then attempted to climb up on the scaffolding.
Right.
I'm sorry, I missed that.
That might be a good argument if he hadn't then tried to climb up onto the scaffolding.
And the windows had to be unlocked by according to the fire code.
Your Honor, there was no way to the fire escape except what I read to you from the defense expert. Once you're out there, if you think that's the exit, you are, particularly in that condition, you're absent. You're going to be injured. That's likely to occur. And of course, it's a tavern, so it's not exactly unforeseeable that people get plastered in your tavern that you depend upon for your income.
Thank you. Goldberg v. Weprin.
Good afternoon, Your Honors. Matthew Hurl for the plaintiff appellant. Your Honors, it's our position that Mr. Wurzberger, as a partner in a partnership that was undertaking a real estate transaction, is liable for the legal fees that were incurred by the partnership.
Anywhere in the record where there's either Mr. Wurzberger signing off on your being his lawyer or having communication with someone in your firm that would be consistent with his belief that he was represented by your firm?
Well, there are emails from Mr. Wurzberger to myself and to Ms. Kessler talking about factors of the representation.
But in those, he was not representing him, holding himself out as your client, but negotiating.
Oh, no, Your Honor. No. And that's something that we have to keep sight of here. And one of the things that the trial court looked at was Mr. Zwick was an attorney for Mr. Wurzberger. So the trial court said, well, he was represented by counsel. There's two separate things here. Mr. Zwick was Mr. Wurzberger's counsel, no doubt. But we, Goldberg Weprin, were the transactional attorneys for this transaction. Mr. Wurzberger had Mr. Zwick to negotiate with his partners, Mr. Klugman and Mr. Hirsch, and Mr. Zwick was involved throughout. But
How do you explain that you didn't send him an invoice until 4 years after you sent the invoice to?
Hirsch and Klugman.
Right.
Hirsch and Klugman were the people who came
I
to
want
our...
you to focus on the 4 years.
Well, I will, because Hirsch and Klugman were the ones who created the transaction, and then Mr. Wurzberger joined the transaction. They were the people who the invoice was addressed to. When the matter was opened, it was opened up in their names. They then took in Mr. Wurzberger as a client. We pursued after the transaction was over, because we got substituted out when the litigation resulted, and we sought payment from Mr. Hirsch and Mr. Klugman because they were our direct contacts. They told us subsequently, after we were taken out, that Mr. Wurzberger had bought them out of the deal, and that he was responsible for the legal fees because he had bought their positions.
But so just following up on that, up until they told you we can't pay your bills, go to this guy, you had no understanding that Mr. Wurzberger was going to be responsible for these bills, did you?
No, yes, we did, because he was part of the deal. But the bills were sent to the partnership, which was opened up in the name of Hirsch and Klugman, because they were there first. They came to us. They had been pre-existing clients of ours.
Counsel, you realize that it's like a huge leap of faith that you're asking us to take. I mean, what were the terms of your agreement with Mr. Wurzberger?
Mr. Wurzberger came into the terms of the agreement where we were paid hourly for the transactional work we were doing.
And
what bound him?
That out? Where
What
was that in writing?
Right.
There is no retainer signed by Mr. Wurzberger. There is a partnership that was billed for the transaction that was underway. Mr. Wurzberger joined the partnership. There's nothing that says we're going to be billing you at $80 an hour or $100 an hour. But the invoice was issued, and Mr. Wurzberger, as a member of the partnership, is responsible. Now, I just want to address the three underlying bases that the trial court looked at to say that Mr. Wurzberger wasn't a partner. She said that Mr. Zwick was involved, and I think I just touched upon that. Mr. Zwick was his personal attorney, not the transactional attorney. She said that the agreement that Mr. Wurzberger signed with the partnership agreement in March of 2014 was not a binding agreement. It wasn't an agreement reflecting a partnership, but it was an agreement to agree. We respectfully disagree. We believe all the terms of a partnership were there: sharing of profits, allocation of losses, what should happen if the apartments were sold.
Mr. Wurzberger agreed to share the losses?
Mr. Wurzberger agreed to, the losses would be deposits, which there was an allocation of what would happen to the deposits, and closing costs. So those are the only losses that face.
Those are losses?
Those would be the losses that would be in the effect of a contract buying a piece of real estate. Who's responsible for costs?
Counsel, you got to look at Lebedev, because that doesn't, I don't know that those work as losses.
And then finally, the other basis for the judge saying that he wasn't a partner was he says, I'm not a partner. He submitted an affidavit that says, you guys didn't represent me.
You have time on rebuttal.
Okay, thank you.
Good afternoon. May it please the court. Mark Kranz for the respondent and defendants in this case. As Your Honor.
Counsel, could you just, continuing along the question,
Yes.
the lines of the question I just asked, at what point did the defendants agree to share in the, specifically Mr. Wurzberger, agree to share in the losses?
Your Honor is right. There is no such, it's not in the record. Actually, this letter agreement that counsel's referring to refers to a future operating agreement that they're going to enter into. It's not in the record.
That was never consummated.
Yeah, and they had a lot of time during this case to depose all sorts of parties. And the motion for summary judgment was made after the close of discovery. So Whatever is in the record is what was before the court, was the information that they had. So that they have this whole idea that there was some sort of partnership and they're trying to get Mr. Wurzburger and his companies in because there's a partnership. There's so many other evidence aside from this. For example, Your Honor, most of this work was before Mr. Wurzburger even became involved. Most of the stuff that's in their invoice. And as Your Honor said, the invoices were billed to their clients. It was sent 4 years later. We have on everything. Mr. Wurzburger had his own attorney. Mr. Wurzburger's Jeffrey Zwick. He even has an affidavit that he came into their office, Goldberg Weapons office, for an actual meeting where he represented Mr. Wurzburger. So there's so much. They don't even have testimony about this so-called partnership. Their own clients, they didn't even have an affidavit from their own clients, which they could have easily done.
From Mr. Klugman?
Yeah, it's not there. It's so easy. They didn't even bother with that. A few other very, very quick points. So most of Mr. Wurzburger's companies that they're suing were formed after the fact, after the date of the invoice. It doesn't even make sense how they can possibly be involved. Another very strange thing I'd like to bring to the court's attention. They asserted attorney-client privilege in connection with discovery. When we sought discovery against them, they asserted attorney-client privilege, and a lot of discovery they didn't give us. So 1 second, who are you representing? There's something very, very strange here. Aside from those points...
Asserted attorney-client privilege as to which communications?
As to communications in connection with this whole transaction. It's very, very strange. You're saying you represented us, but you're not giving us documents? How does that make any sense? That almost goes into like an ethical issue. It's very strange. The last thing I'd like to point out, which the lower court did not mention, but I think it's worthwhile mentioning, there's a requirement that they allege in a complaint that when you're suing for legal fees, that either the party defendant has a right to arbitration or that the case is otherwise exempt. There's no such allegation, and that's just a procedural nuance, but without that, the complaint should have been dismissed on that ground alone. But that's not addressed to the lower court, but I just wanted to bring it up. Thank you.
Thank you.
Quickly to address a couple of those points.
Well, one thing, Counsel, I did find interesting is even in Judge Bannon's decision, she talks about, your statements as to the terms of the agreement between Klugman and Hirschman, that, that there was no memorization of this. You never submitted an affidavit from Klugman or from Hirsch?
No, they had moved to Israel, Your Honor, and then we ended up pursuing them.
You couldn't get an affidavit?
We did not, and we ended up having to sue them as well, because as justice, good for the goose, good for the gander. As we sued Mr. Wurzburger as partners in the deal, so were they. But now, just to address counsel's points, the attorney-client privilege was asserted because some of the demands exceeded the transaction we're talking about. They were looking into things that were, because Hirsch and Klugman were...
You said everything. Said you asserted attorney-client privilege for everything.
No, it was asserted to do some demands that were far in excess. There was discovery produced for this transaction, as you see in the record. There was billing records, there was communications, there was emails, where the scope was beyond the transaction, and it dealt into transactions with our clients, Hirsch and Klugman. That's why we asserted it.
You have a document, new matter memorandum, where it clearly shows that your client was quality.
Yes.
Mr. Klugman.
Yes.
What document in the record shows that you represented his client?
Because that document was filled out before Mr. Wurzburger joined. That document was
You're
filled
an
out.
attorney. Bring him in. Have him sign.
He joined a partnership. He joined a partnership that existed between Klugman and Hirsch.
And there was no and you're claiming that you went ahead representing him without any documentation that you were representing him?
But then he signed this agreement in March. He attended the meetings. He negotiated. He submitted documents.
He signed on his own behalf.
That we then
I'm sorry, which agreement do you claim that he signed that proved that he was your client?
That he joined this part. The March 4th agreement is an agreement for the purchase of for these units that we were representing. We were entering into a contract. We already had a contract for 2 units.
But in that agreement, he's not represented. There's no representation that he's represented by you, correct?
He had his own, in other words, he had his own counsel there.
He had his own counsel
He signed on his own behalf.
for the relations with his partners. The transactional aspect of the deal, buying the units, was that group of people, the collective of Hirsch, Klugman, and Wurzburger.
So we go back to the whole thing of was there a joint venture or not?
Exactly. The joint venture, he was a partner in a joint venture.
And you're
We
saying-
represented the joint venture, not him.
And you're saying that Mr. Wurzburger agreed to share in the profits and losses, specifically the losses,
Yes.
but it's not written anywhere.
To the extent that there is an allocation for losses, closing costs, loss of deposit, and so on, that is in the agreement.
Thank you.
Thank you.
Weiss VV. We lost somebody.
Your Honor, I present the respondent as downstairs earlier and saw appellant's counsel. I know that this is simulcast downstairs. If I could speak to the camera, I'll. Oh, no need.
Apologies, Your Honors.
The clock
Lost
is ticking, so
No
you're
problem.
almost out of time, but go ahead.
May it please the court, my name is Joshua Deal. I'm here on behalf of appellant. First of all, I'd just like to say that there's sort of two ways to view this declaration and interpreting how the easement for water access applies to my client's terrace. First of all,
Is there an easement?
yes, Your Honor. In Article 11A of the declaration, there is a cross easement for access to water service, electrical service.
The units.
Correct, Your Honor.
And the definition of unit does not include, only includes the interior space. It does not include exterior space like a terrace. So
Well-
why does the cross easement give your client access, give your client a right to an easement for the purpose of getting water to his terrace?
Sure, Your Honor. The residential limited common elements like the terrace are for the direct and exclusive access of a unit.
Right,
They are
but I'm
pertinent-
sorry, but the easement is only for the purposes of something necessary to the unit.
To
And
service
the
that.
residential limited common element is not in the unit.
Well, Your Honor, the unit does include what the declaration defines as facilities, and the facilities include access to all water fixtures, things
Facilities
of that
doesn't
nature.
include terraces.
Well, Your Honor, the terraces do have facilities annexed to them. So there's a water spigot, there are electrical outlets, things of that nature on the terraces, which are for the exclusive access of their pertinent unit. They're necessary, therefore, to service that
So
unit.
I'm going to pursue a different tack. And neither of you, I believe, addressed this. On record page 51, Exhibit B to the Declaration of Condominium references both apartments, 11C and 11D, and it is entitled Description of the Units. So this is an exhibit to the deck, right?
Yes, Your
And
Honor.
it says it has under terrace square footage, it lists the terrace footage, right?
Yes, Your Honor.
So one could argue that the description of the unit is here, because if you look at the description of the units elsewhere in Article 6, not every unit includes a terrace.
Correct, Your Honor.
The description of those units which have a terrace is found in 51.
But counsel, did you make any argument based on Exhibit B to the declaration?
Well, I may not have specifically.
I meant specifically, that's how we make
Well,
arguments.
Your Honor, I certainly relied
Did you
on
make any
it
arguments specifically related to Exhibit B to the declaration?
in describing the unit and what my client's ownership of that unit includes. I did, Your Honor.
But you didn't use that as a hook with regard to the easement, did you?
No, Your Honor.
And is there anything in the declaration of the condominium, the square footage, et cetera, which shows that there would be a cross easement?
I'm sorry, I don't understand
Is
your
there
question.
anything in the description? The description says that units 11C and 11D have terraces, but it also states that the terrace is not a part of the unit, right?
Correct, Your Honor. I understand your point,
And to take that one step further, in fact, the terraces are defined under 7C, where it says that it's a residential limited common element. And when we get to the articles that pertain to the easements given to residential limited common elements, we're not necessarily talking about 11, we're talking about Article 10A, right?
Yes, Your Honor.
Okay.
Thank you.
Good afternoon, Your Honors. David Wolf for the respondent.
So, counsel, with respect to Article 10A, at the end of that paragraph, which is kind of long, it talks about the residential limited common elements. A terrace falls under that description, and it says that that they shall have direct and exclusive access, except in accordance with the reasonable purposes for which they are intended and without encroaching upon the rights of other persons to do so. You all are involved in, you have discovery going on right now?
No, Your Honor. Our pre-answer motion to dismiss was granted on the basis that the easement granted in 11A only applies to the unit and not to the terrace, which is outside of the unit and is a limited residential common element. It's accessible only by the appellant, but that doesn't make it part of the appellant's unit. And similarly,
So I have a lot of confusion here because there's a lot of gaps in the papers for me. The access to the shutoff valve is inside the 11C. Is that correct?
it's in the respondent's unit, yes, Your Honor.
Right. So I don't understand how you get access to that that shutoff valve. If it's a question of someone's leaving, 11C's leaving it on all day or turning it off at night, I don't, or if other people are in a similar situation, what's the history of this? There's nothing.
Well, the question really is, does the easement granted by 11A apply to residential limited common elements? It doesn't, and I'll get back to that in a moment. The question that, or the argument that the appellant makes, and that I believe your question is really touching on, is, well, why should there be a spigot on my terrace and a shutoff valve in your unit unless I have an easement to it? And the answer to that really is, and this is consistent with more than 100 years of New York law, you might buy your apartment because you like the light, the air, and the view. But if a developer comes in next door and puts up a new building, unless you have an easement for your light, your air, and your view, you don't have an easement for your light and your air and your view. So does the appellant have an easement for the water servicing this spigot? And the answer is no.
Does the offering plan say anything?
I'm sorry?
Does the initial offering plan say anything, or the amendments to the offering plan?
I don't know. That's not in the record, Your Honor.
It's not.
It is. But the issue is really.
Well, I mean, but did anyone put it in? I mean, did
the
your
appellant
adversary put in the offering plan or anything like that?
The appellant didn't put it in, though they had that opportunity. And secondly, and really firstly, the complaint alleges the existence of an easement set forth in the declaration. So the declaration is in the record because it utterly refutes that allegation, and
I would
it
agree
refutes.
that the exhibit, though, Exhibit B, is part of the declaration.
I don't know what you're referring to, Your Honor. The
51.
exhibit to the motion or an exhibit?
Exhibit B to the declaration of condominium.
Oh, it is part of the offering plan. Is part of it. I'm not aware. But what I could specifically speak to today is, and again, you have some questions which relate to arguments that weren't raised. So I apologize if I'm not
focusing on them as sharply as I otherwise would have been if the appellant had made an argument along those lines. But we have a very specific clause here. May I
Please
just briefly?
continue.
Thank you, Your Honor. We have a very specific clause in the declaration addressing pipes, conduits, and utility distribution systems. And that easement for pipes, conduits, and utility distribution systems is expressly limited. It says that it is to the extent that it serves a unit, unit's a defined term and the terrace isn't part of it, or is necessary to serve a unit. Now, in the face of a specific clause setting forth a limited easement, the appellant is claiming not a specific, they're looking at general terms. Facilities means appurtenances means elements. I mean, it's sort of a word salad that's almost hard to re-articulate for the purpose of debunking it, but that only further shows how wrong it is. There's nothing to harmonize here because there is no inconsistency. There's an express easement for water pipes leading to the unit. There's no implied or other type of...
I have a question about a slightly different issue. It seems to me the counts 1 through 3, 4, and 8 all make claims against your client that concern matters other than or in addition to the water. What basis was there for those to be dismissed?
Our memo of law is part of the record.
Yes.
And we didn't want to regurgitate all of it because there was no arguments made for reversal of those. But down below, we specifically made arguments as to each individual cause of action. For example, with respect to the prima facie tort. In order to plead prima facie tort, you need to allege special damages. In other words, an exact number that I was harmed in a specific way by this sort of...
But if, for example, but why doesn't, for example, count 4 constitute a valid claim that your client breached the bylaws by violating the garage rules and engaging in harassment?
Oh, okay. So, forgive me, Your Honor. Where I was going with my, apologize, might have been more long-winded than should have been, response to your earlier question was, we raised all of those arguments below. The judge agreed with our arguments. He didn't set forth his...
He didn't say anything about them. He just happened to say, put an S on the end of claim.
Well, he didn't, and that's the judge's prerogative as to how much or how little to put into the decision. It shouldn't be reversed and thrust the defendant back in the position of having to re-defend it merely because the judge didn't expand on his reasoning. Frankly, the onus as appellant was on the appellant to say, we pled these causes of action. They raised these arguments in opposition to it, and these are the reasons those arguments by the defendant respondent were wrong and that the decision should be reversed. They didn't do any of that. And we even say this in our respondent's brief. We say, in addition to this cause of action, there were X number of other causes of action.
But the appellant did address that in point 2 of their brief to us.
No, they argue simply that it should be reversed because the judge didn't say why it should be dismissed. And we respond by saying the judge's terse decision, just the fact that the judge erred on the side of brevity instead of, for example, the type of long-windedness that I've been guilty of today, isn't a basis for reversal. Show me a substantive argument. If you want to reverse a judge, because how many times have we seen motion granted, motion denied? You don't need to give this specific legal reasoning for each of the many causes of action.
Thank you.
We raised specific arguments below, and it was their responsibility to show reasons why they should be reinstated, not for us to say, well, you didn't argue this, but if you did, this is how we would have responded.
Thank you.
Thank you, Your Honor.
Just to back up to one issue that was raised by Your Honor as to whether I specifically discussed the definition of the unit as including the terrace. What we did argue in our papers and have argued today is that the rights of use and enjoyment of that terrace are the sole province of the unit to which it is appurtenant. And for that purpose, the terraces must be considered as appurtenant to a unit and therefore bundled with the same rights of use and enjoyment as that unit.
But what is the then step going from you have an explicit easement for the purposes of the unit, but what gives you an explicit easement for the purposes of things that are pertinent to or helpful to the unit?
Sure, Your Honor, and
Seems to me a big jump.
well, you must read the document as a whole at that point. And our view is that reading it as a whole and including the definitions of facilities included in the document demonstrate that those facilities that are part of the unit, defined as part of the unit, include the pipes, spigots, things of that nature that are both appurtenant to, affixed to, and servicing that unit.
So, counsel, looking at, going back again to paragraph 10A, where it talks about nobody can use what's in a residential limited common element to which a residential unit has direct and exclusive access. Okay, so just thinking about that section of the paragraph, to the extent that the
spigot.
No,
the shut-off valve.
Oh, the shut-off valve, sure.
To the extent that the shut-off valve is inside somebody's unit, like where they live.
Yes, Your Honor.
Is that considered exclusive access, or is it shared access? Do you in your papers indicate why it would be shared as opposed to exclusive?
To the shut-off valve specifically, Your Honor, I do not discuss that in the papers, Your Honor. However, I think
that's the whole issue. Isn't that the whole issue? Is access to the shut-off valve because allegedly he was not receiving the water because of the shut-off valve?
well, yes, Your Honor, except at a certain point, it doesn't matter where the shut-off valve is, right? He's entitled to the access to the water regardless. So the fact that the shut-off valve is
But
in...
you're jumping hurdles that aren't there, because he's got his own water in his own apartment, unit, sorry, and she's got water in her own unit, but she has something extra, which is the shut-off valve. So to the extent that it's in her unit, why is there shared access as opposed to exclusive access? That's really the issue that we're confronting here.
Thank you. Thank you both.
Thank you, Your Honors.
Last case for argument is Memejaz versus Brotherhood Synagogue.
Good afternoon, Your Honors of Police of Court. My name is Debbie Ann Morley. I am counsel for IRL Systems. I'm with the law firm of Marshall, Conaway, Bradley, and Gullub. The issue on appeal in this matter is essentially a very discrete issue. Oh, sorry, I keep forgetting I'm on the 5-2. The issue on appeal is a discrete issue. This is a third-party action against my client for contractual indemnification. The issue, there are two contracts at issue in this case. There is a 2007 contract, which...
And a 2016 contract.
Yes, Your Honor.
What is your theory as to why the 2016 contract doesn't replace the 2007 contract?
Well, the 2016 contract is for a specific central connection. It is not a superseding contract. It is for a separate duty. The 2007 contract is a maintenance contract that it requires routine and regular interval maintenance.
Does the 2016 contract contain a merger clause?
I'm sorry, the
Did it contain a merger clause?
It does, however, there's been no, the first contract is for a separate scope of work. It's not a continuation, it's not a modification. These are two separate scopes of work. One is for regular maintenance and routine maintenance that is required for maintaining the integrity and functioning of the fire alarms. The other contract is to ensure a contract that is for ensuring that the fire alarm system is connected to rapid response, which is merely a monitoring contract and has nothing to do with any regular basis.
So, counsel, looking at the paragraphs 13 of the 2016 agreement, it does say supersedes and replaces all prior understandings or agreements, whether written or oral, relating to the work to be performed pursuant to the agreement. So you are saying that the agreement pertains only to the work that's in the 2016 agreement and not to all agreements?
Precisely, Your Honor. Both Mr. Torres, the building manager, as well as the CEO, Mr. Lally of IRL, testify that there are two separate contracts, not one contract that ended and is superseded or was modified, but that there are two separate contracts with two separate scopes of work. There has been no indication, no evidence at all that the 2007 contract was ever canceled. In fact, that contract specifically states that there's to be a 30-day cancellation notice. No one has produced any indication that that contract was separate or in any way modified or merged into the new agreement.
There's a merger clause in the 2016 contract. And the 2016 contract talks about indemnification, where in the 2007 contract does not talk about indemnification.
Yes, Your Honor, we do not dispute that. The issue is not whether or not the 2016 contract contains a merger clause. The issue is these are two separate contracts for two separate scopes of work. Just because an entity enters into multiple contracts with another entity does not make it for the same scope of work.
So you have a 2007 contract which does not talk about indemnification, and then you enter into a 2016 contract which does talk about indemnification, and also has a merger clause. And you're saying that these are two separate contracts?
Yes, Your Honor, there are two separate scopes of work, have two separate subject matters. The 2016 contract does not have any work associated with it. It is mainly to
2016, does it?
The 2016. That contract was testified by Mr. Lally. That contract was only with respect to the Central Station connection. The work contract, which is a regular contract, which states on the first in the first paragraph that there are inspection and maintenance, routine maintenance is required every 6 months. That's the work that was going on at the time.
You have time on rebuttal. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court, Robert Von Hagen from Molad, Spitz, and DeSantis for the respondent.
Two separate contracts?
Well,
Different
Judge,
work being performed?
The paragraph 1.2 of the 2016 contract specifically articulates fire alarm test and inspection services, making it within the scope of the 2016 contract. The merger clause eliminates the use of parole evidence. So all of this back and forth about Mr. Lally's testimony, Mr. Torres's testimony, it's really unnecessary once the two of them agree that the 2016 contract is valid. Once you make that determination, it's the court's role to look to the four corners of the contract, and you have a merger clause. You have a provision about fire alarm testing and inspection, which is what Mr. Mamaj was doing when he was at our client's property. It's on all fours, the agreement. I would ask the court to search the record and to look at the indemnification provision and to look at the arguments that we make about conditional indemnification and why the lower court would have denied us the opportunity to turn to our reputable licensed contractor who held themselves out to do this service, who agreed that they were going to provide their client with a ladder, going to provide their employee, with training, with services, with a coworker, which is all undenied in the record. I would ask the court to search the record and grant conditional indemnification to the extent that a jury finds that they were negligent in not providing these services to both their own employee, but also to our client, more importantly.
Are you questioning it at any point whether the accident took place on the premises?
That's in dispute for different reasons, Judge. I don't think it has any bearing on this appeal. There is evidence from Mr. Torres that no one witnessed it, which is actually undisputed, that it went unreported, which is actually in somewhat of a dispute, but has nothing to do with this appeal.
This is only as to the contract and indemnification.
Yes, Judge. Concede is such a dirty word in this chamber, at least on this side of the bench. So I'm not going to concede that the accident happened. But
I understand. Thank
okay.
you.
Thank you, Your Honors.
Addressing two initial points. Council does not argue in the case below for conditional.
Mike.
I have to. I believe I'm much larger in my own head than I am.
We appreciate that.
You're taller, much taller in your
I
own head,
understand.
Yes.
Council argues only for the first time on appeal for conditional indemnification. That argument was never brought forth. That argument was never made previously. Council cannot at this juncture make that argument. With respect to the contracts, both, again, and I hate to repeat myself, however, both the building manager and my client acknowledge that there are two contracts, but but there has never been any acknowledgement that these contracts contain the same scope of work, nor that the contracts were in any way modified. In fact, my client testified that when a customer retains his company, there are two separate contracts. One for maintenance and one for central station connection.
Thank you. Thank you both.
Thank you, Mike.
Thank you.